Hey guys, I have a great question from Victor Gonzalez. So does a notarized bill of sale or a receivable sale agreement from, let's say, a seller, Capital One, to Sherman Originator 3 LLC, and then from Sherman to transfer the assets to LVNV Funding LLC? How do you answer a disclosure statement? Also, what if the plaintiff asks you to show a genuine dispute of facts on the motion for summary judgment, and then cites some case law from Georgia and somewhere on the West Coast? And ends it with, anyhow, any help would be useful here on this matter. What if LVNV has a plaintiff affidavit of indebtedness and ownership of account that is notarized? Is that legitimate ownership? Then what do I say? So let me say, first of all, it sounds like been sued by LVNV Funding, and they filed a motion for summary judgment, which is a very dangerous thing for consumers. And that means if it's granted, there is no trial. The case is over. Judgment is summarily entered against you. And so you've got to respond to this correctly. And I'll tell you this, most consumers don't do this right. And frankly, a lot of lawyers don't do it right. But really, really hard to do this on your own. What you have to show, at least in Alabama and in federal court, and I assume it's the same whatever state you're in, but check with a lawyer in your state, is you have to be able to show that there is what's called a genuine issue of material fact. Material fact meaning a fact that's important. Like, did the LVNV really buy the debt? That would be important. Is there a genuine issue of material fact about that? In other words, if it was a jury, could the jury rule in favor of LVNV or in favor of you? Or if it's a judge, could they rule one way or the other? Well, then summary judgment's not appropriate. And then LVNV has to show it's entitled to judgment, what's called as a matter of law. And so if you start off with Capital One and it goes to Sherman Acquisition to LVNV, my view of this, what I've argued for many, many years, is you sort of trace your way back and say, okay, LVNV has to prove it bought the debt. Well, who did it buy it from? Sherman Acquisition. Okay, if it can prove that, all it's proved is Sherman sold it something. Okay, I could sell you the Brooklyn Bridge. It doesn't mean I actually own it. So now we go back to Sherman, and Sherman's got to prove that it actually bought it from Capital One. Well, can they do that? Maybe they can do that. Is there somebody from Capital One that can come in and say, yes, we sold this to Sherman? And like we always talk about, get the purchase agreement. That's the true proof of ownership. But there's going to be two purchase agreements. There's going to be from Capital One to Sherman and from Sherman to LVNV. And I would argue both of those have to be there. They have to be witnesses from Capital One, from Sherman, and from LVNV to try and prove this. Now, in terms of how you dispute this, well, first of all, you can give your own affidavit and say, to my knowledge, Capital One has not sold this to Sherman Acquisition, who did not sell it to LVNV. Now, it certainly is better if you can take depositions. So you take a deposition of somebody from Capital One and Sherman Acquisition, LVNV. And so this can get a little complicated because you have to follow the rules for summary judgment, which is Rule 56 in the federal rules, Alabama rules, and most states follow that same pattern, be considered Rule 56. But it's very dangerous, and just be blunt, it's complicated to do that. And so I would definitely talk to a lawyer in your state, get an idea of what are your options here, how much will it cost to hire the lawyer to fight this? Does the lawyer recommend that you settle it? What do you do? But I'll tell you this, the more steps there are, the better for you, because those are all steps that they have to prove, that sort of chain of title. So LVNV's got to say, well, we bought it from these guys, but that's not enough. They have to prove they bought it from Capital One. Is there anybody else involved? Maybe there is. And the connection between Sherman and LVNV is typically things are sold to one of these Sherman companies, and there's a whole bunch of them. It may get bounced around to several of those, and then it may go to a company called Resurgent, and then to LVNV. So I've seen these things where maybe there's 5 steps involved. Well, they better get 5 people swearing under oath and offering purchase agreements and all sorts of proof. That's the approach that I take with it. So hope that that's helpful. Definitely get yourself some help on this, whatever state you're in, to help you with it. And thanks for the good comment, and thanks guys for watching this video.